My name is Kelly Balamuth, and I'm a plaintiff's personal injury and medical negligence attorney in Northern California. This personal injury minute is about why it's so difficult to find an attorney to take medical malpractice cases. There are very few attorneys left in California who handle medical malpractice cases, and that is largely because of MICRA, the Medical Injury Compensation Reform Act, which was passed in 1976. That act protects doctors in a way that other professionals aren't protected. In California, the law is that if you commit negligence and your negligence hurts somebody, that you're responsible to pay compensation to that person for the damage that you caused. But the Medical Injury Compensation Reform Act created doctors as a separate category. They can more easily escape liability for their wrongdoing. The practical realities of MICRA are that there is a $250,000 cap on pain and suffering damages. That means that if your case were to go to a jury and the jury were to award you $1 million in pain and suffering damages, the judge would lower that to $250,000. Now, medical malpractice cases are really expensive to pursue. That's because you have to hire experts that will testify against the doctor. It's difficult to find doctors who will testify against other doctors, and when you do, they charge a lot of money. So attorneys tend to put forward those costs in order to bring the lawsuit. And the problem is, because of the MICRA cap on damages, in many cases, the costs of pursuing the case are outweighed by the total amount that you can expect to get at the end of the case. That means that even if you've been horribly harmed, unless you have a lot of out-of-pocket damages, a lot of wage loss, and a lot of medical bills, it's very difficult to bring these cases in a way that will actually get you compensation. In all medical malpractice cases, you have to link the negligence to the injury. That's called a causative link. And in medical malpractice, because usually you're going to the doctor because you already have a problem, it can be difficult to show that the negligence caused the problem, because typically we're not 100% healthy anyway when we're going to the doctor. If you or I were to hit somebody with our car, our insurance company could settle any claim against us without asking whether or not we want to settle. But doctors can withhold consent from a settlement, which means that if you file a lawsuit against a doctor for medical malpractice, they can push it all the way to trial, even if it's a case that is really meritorious. Trials are very expensive, and so medical malpractice attorneys are extremely cautious on what cases they take, because there's a far higher chance you're going to end up trying the case to a jury than, say, a case where you're injured because somebody hit you with a car. So those are the reasons that it's really difficult to find a medical malpractice attorney, and it can be extremely frustrating to people. One thing that you can do that doesn't get you compensation, but that will at least have a doctor or a hospital investigated for potential wrongdoing, is report your situation to the California Medical Board. You can look them up online. They have a process by which injured patients or wronged patients can make a complaint against a doctor or a hospital.